Good afternoon. I'd like to call the Senate Finance and Appropriations Committee to order, and the clerk will call the roll, please.
Senator Saslow. Senator Norman. Here. Senator Hanger. Here. Senator Lucas.
Here.
Senator Newman. Here. Senator Ruff. Here. Senator Vogel. Senator Barker. Here. Senator Edwards. Here. Senator Deeds. Here. Senator Locke. Senator Peterson. Here. Senator Marsden. Here. Senator Evan.
Here.
Senator McClellan. Here. Senator Howe.
Here.
Madam Chair, you have a quorum.
Edwards, I'm here too.
Yeah. Okay. We're going to hear most of the remaining bills that are in this committee this afternoon, so it may be a longer meeting than we've had recently. But there are several bills that have not been docketed at the request of the chief patron, so we will be having another meeting at some time. We are allowing public comment on 3 bills: Senate Bill 5071, Senate Bill 5113, and Senate Bill 5119. These bills, we are their first hearing on these bills. All the other bills have been heard in another committee previous to this one, and the public has had an opportunity to speak to them. My understanding is that we have 3 people who have asked to speak, but 2 of them wanted to speak to Senate Bill 5119, which the patron, Senator Ruff, is planning to strike. So do they still wish to speak? No, they do not wish to speak. Okay, and I understand we also have 1 person who would like to speak to Senate Bill 5071, Senator Cosgrove's bill. So somewhere out there in Zoom land, if the person would like to speak.
Yes, ma'am. This is Ron Jordan speaking on behalf of Chesapeake Public Schools. We're asking you to support Senator Cosgrove's bill. We think it's a good transitory step in allowing us to better recruit school security officers to the bill you all passed during the regular session, and we would ask you to support it and send it over to the House. Thank you.
Okay, thanks, Ron. All right, we are going to go in this order. Next, we're going to hear non-committee member bills, and after those bills, we will hear committee member bills, as is our tradition. The first bill up is Senate Bill 5018, Senator Bell.
Thank you, Madam Chair. This bill was heard by the Senate last year, and it passed on a floor vote of 23-15. It's the compassionate release bill. The basis for this bill comes from a JLARC study that was done that actually recommended that we change our compassionate release of terminally ill prisoners from 3 months to 12 months. The problem with the current release at 3 months, it's very hard for a terminal diagnosis to be precise, and by the time the applications are filed, often the prisoner has died, unfortunately. This would be for prisoners who in many cases are not eligible for parole, and it would just give a mechanism for the parole board to consider. It would not guarantee parole, just a mechanism. We've heard the merits, I know, of the bill in the committee. For the Finance Committee, I'll say that this bill has a chance to save a significant amount of money. Typically, the care of terminally ill prisoners is very expensive. Often involves multiple officers to take the prisoner to a specialty care facilities, which might be needed for cancer treatment otherwise. And the types of treatments are very expensive. The estimate on this through the JLARC study was to save over $50 million per year. The original bill included the cost, it was in the governor's budget previously, which I know has been reallocated for 1 additional part-time parole examiner. There are protections to make sure no one would get released from this. There is a care plan and a place for them to go. I will say lastly that I think the COVID connection here is a very close connection. If someone's terminally ill and they were diagnosed with 12 months, if they were to, frankly, catch COVID, that's almost an immediate death sentence for that person. So there are severe impacts there. And again, I think this gives people who have served a great deal of time, 80% are completely bedridden, a chance to make amends, hopefully with their family and those that they've offended. And I believe it is the right thing to do. I often look at justice, and without mercy, I'm not sure we really have justice. So with that, I will be happy to answer any questions the committee may have.
Are there questions for the patron?
Madam Chair.
Yes, Senator Hanger.
Thank you. I have a question for the patron.
Yes.
And I would say that I supported this bill last session and continue to support geriatric release reviews and terminal ill. Where I have a concern is in the area of those who have disabilities. And I know maybe we're not supposed to do this, but I was just curious from the patron that passed the Senate, what was the main objection that you found in the House?
Madam Chair, I presented the bill to House Course Committee, and honestly, the court's chairman, Delegate Charnel Herring, had decided she wanted to have the Crime Commission look at this, even though it had previously been studied. So the decision was made that that's why it wasn't going to pass.
Okay. Madam Chair, follow-up question?
Yes, Senator Hanger.
My concern, I would say to the patron, is the sentence section or numbered 4. Anyone who is permanently or physically disabled is eligible for consideration. That one, I guess, is my concern that I have now that I really hadn't focused on last year. Would you be amenable to striking that particular provision?
Madam Chair, to clarify, we're talking about the wording that is after the terminally ill, so it would be or who is permanently physically disabled and eligible for consideration. Is that correct?
Madam Chair, yes, I'm just getting at that particular section where one of the qualifications would render eligible for their early release under this provision would be someone who is permanently or physically disabled.
Madam Chair, I would be amenable to that change.
Sorry, I didn't. You would be?
Yes, Madam Chair.
Okay.
She would be, he would be. Madam Chair, I would offer that amendment to.
Madam Chair.
Senator Evan.
Just to ask, and I don't know if this is for Senator Hanger, where it says is permanently disabled, would he be amenable to changing his amendment to who becomes permanently physically disabled? In other words, becomes disabled while they're incarcerated rather than goes in disabled, or does that not answer your objection?
Madam Chair, if I can address that.
Senator Bell.
One of the things, even though Senator Hanger, I appreciate your indulgence if I'm trying to answer your question. But on this one of the things that we did grapple with since I presented the bill in the committee here this year at the special session was there are some labels of disability which could be diagnosed onto a prisoner and frankly possibly could lead to a release that we may not want. This is intended really for the terminally ill. I would recommend if we were to strike that entire sentence that Senator Hanger had addressed, it would make rewording it in the way that Senator Evan just mentioned a moot point because it would be gone. So, I would think we just get rid of that one sentence and it would fix that problem.
You. Madam Chair, that would be my amendment that I would offer.
Madam Chair, would be my second.
It's been moved and
Madam Chair.
seconded. Discussion on the amendment.
I got a question.
Yes, Senator Edwards.
Yeah, I guess this would be the patron, Madam Chair. So you want to and Senator Hanger wants to delete line 23 where it says or, who is permanently physically disabled is eligible for consideration. At what point do you want to delete, I guess, from or Romanet 4, who is permanently physically disabled? That's what you want to delete? Is that correct?
Madam Chair, it would be item 4. So it would delete the or through the basically the permanently disabled, but it would keep the terminally ill, which is frankly the target of the bill.
Madam Chair.
Madam
Senator
Chair, so
Edwards.
I'm going to clarify this. So you would keep the language "is eligible for consideration," right? And just delete the "who is permanently physically disabled."
Madam
Is that
Chair, that
correct?
would be correct.
Is that correct?
That's correct, he said.
I got a question, Madam Chair.
Senator Edwards.
What's wrong with leaving it the way it is? I don't understand. If somebody's permanently physically disabled, they're still being could be considered. It doesn't mean they're going to get out automatically. It's just something the parole board should consider. What's wrong with that?
Madam Chair.
Yes.
Madam Chair, just speaking to the motion, because this was exactly my concern. I have a real concern that you end up with someone who may be physically disabled, but maybe their crime was a sex crime or a financial crime using the computer, and we are going to at least put into the queue an individual that could meet those items. The terminally ill is pretty clear on where that goes. So kind of speaking to the motion, Madam Chair, I hope we would eliminate little item 4 and also take out lines 14 through 16 as they are no longer needed.
Okay, is there anyone else who wishes to speak on the amendment?
Yeah, Madam Chair.
Senator Edwards.
I oppose the amendment. This is only allows the parole board to consider them for release. Doesn't mean it's automatic, but we don't know what people's whether they become physically disabled in prison or is it something that evolves. I mean, it's only giving the parole board some consideration. So I oppose the amendment.
Does anyone else wish to speak on the amendment?
Madam Chair.
Senator Norman.
Thank you, Madam Chairman. The issue I have with it, if you look at the definition that is in the first part of the section, it tells you what the statutory definition in this bill would be for permanent physical disability. Having had some experience with those who enjoy the comfort of the Department of Corrections, they are constantly trying to game the system to find an avenue of release. And this does not require that someone be 100% complete disabled. They could have a permanent partial disability in their right arm, and they are going to try to get a release under this bill. And I don't think that there is a way that we can define it unless you went to something like disability under a Social Security Administration, where you've got to be 100% disabled, unable to perform any type of gainful employment as a result of an illness that is expected to last at least 1 year and documented. I just think that this definition is in itself a problem.
Madam Chair.
Senator Eben. No,
Back
who
here.
was it? Senator Bell.
Madam Chair, again, I hear the arguments on both sides of this. I mean, my number one thing is for the bill was really crafted for those who have terminal illness, which often we would have a permanent disability. But I frankly agree with the points made about permanent disability. I'll read a definition of permanent disability is a mental or physical illness or condition that affects a major life function over the long term. A permanent disability could be as severe as the loss of an eye or as moderate as a broken leg that healed, leaving the inability to walk on grossly uneven surfaces. Given that, I think it could, even though the parole board would not be obliged, they would just be able to consider it could lead into a potentially a release of someone that may not be appropriate to release. So having said that, that's why I have agreed to this amendment, and I think, frankly, it would just focus on the terminally ill, which is reduces the threat greatly.
Madam Chair?
Senator Edwards.
Yeah, let me read the rest of it. Permanently physically disabled means having a chronic or progressive medical condition caused by injury, disease, or illness that renders a person, quote, permanently and irreversibly physically disabled, and such condition renders the person no longer a threat to society, end quote. That's what it says. And it's, again, discretionary on the part of the parole board. So if somebody had a disfigured in jail finger or something, that's not going to, that wouldn't fit into this definition.
Does anyone else want to speak on the amendment? Okay. The amendment is to strike little number 4 and lines 14 through 16. All in favor of the amendment, say aye.
Aye.
Opposed?
No?
The amendment passes. Is there any discussion on the bill itself? Okay, is there a motion to report the bill? Is there a second? It's been moved and seconded that Senate Bill 5018 be reported. I guess clerk call the roll.
Senator Saslow. Senator Norment. Senator Hanger.
Aye.
Senator Lucas.
Aye.
Senator Newman. Senator Ruff. Senator Vogel. Senator Barker. Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Evan.
Aye.
Senator McClellan. Senator Howe.
Aye.
Ayes 13, noes 1, 1 abstention.
Madam Chair,
Yes, Senator Newman.
I know it's a little out of order, but to Senator Bell, just want to make sure, does this include just first-degree murder? Is just for the floor? Does this include first-degree murder? I just don't know what section it's in. I'm sorry, but I abstain because I don't know if it includes first-degree murder.
Madam Chair, it does not include Class 1 felonies.
Thank you, thank you very much. It's helpful.
Okay, next bill is, I would like to go back. I should have, when we were discussing public comment, brought those bills up. So Senate Bill 5071, Senator Cosgrove.
Yes, thank you, Madam Chairman. Senate Bill 5071 is brought because there was kind of a glitch in the bill that we passed last year to allow retired law enforcement officers to serve as school safety officers. It had to do with the break in service. VRS, for some reason, believes that if an officer has already been employed part-time by a particular school system, they would have to stop that job for an additional year before they could go to work full-time. Now, the bill basically allows those people who are already employed as school safety officers to continue working in a full-time basis after a 1-month break. And actually, the bill doesn't even go into effect until July 1st of 2021. So most of those people will be either full-time or go and find something else anyway. The problem we have right now, Madam Chairman, is that if we tell these school safety officers, who have already in many cases developed relations, good relationships and interaction with the students, we're not going to get them back because they're going to have to go find something else to do. So this bill just remedies that, and that's the bill.
Thank you. Are there questions for the patron? Senator Cosgrove, staff has pointed out to me that the IRS guidance speaks to this issue, and failure to meet the facts and circumstances test for a bona fide break in service could jeopardize our VRS plan qualification status and could affect, therefore, all members and retirees.
Yes, Madam Chairman, I saw that in the impact statement, but I don't believe the IRS tells any retiree that they cannot work in any way, shape, or form for a year before they go back to work. And that's what's being remedied by this bill.
Thank you. April, did you have a...
Madam Chair, I just would note that if we want to hear from VRS, we have several representatives from VRS on the call remotely, if you'd like for Trish Bishop to speak to that further.
Of course, let's hear from Ms. Bishop.
Madam Chair, this is Trish Bishop from the Virginia Retirement System. There is, the Internal Revenue Code doesn't preclude folks from returning to work in any capacity, but in a defined benefit plan, the Internal Revenue Code does require what they consider a bona fide break in service. The Internal Revenue Code does not specifically define it, and so we have relied for the past about 20 years due to the teacher critical shortage provisions on a private letter ruling from the Internal Revenue Code that states that a break of 1 year would satisfy their bona fide break in service requirements so that you don't have an in-service distribution. So the challenge is that there isn't black letter Internal Revenue Code law that states what the time frame will be. There was private letter ruling guidance that indicated that a 1 year would be considered to have satisfied what a bona fide break in service is. This is, as Senator Cosgrove noted, it is a closed group of folks. It is a smaller group of folks, so it would not impact retirement patterns per se. And so it's normally our concern, some of our concerns relate to impacts to retirement patterns and the ultimate impact on the fund. This is a relatively, although I'm not exactly sure of the complete number, a relatively small group of folks. But that is the concern related to Internal Revenue Code guidance, although it is not black letter law, and it unfortunately we take a stance that it is to be conservative in our interpretation of the private letter ruling guidance with respect to break in service for return to full-time employment. I hope that's helpful.
Thank you.
Thank you. Are there any questions for Ms. Bishop?
Madam Chairman, Senator Cosgrove, may I ask a question of VRS?
Yes.
Thank you. Thank you for being here today. I appreciate it. The school safety officers who are employed now by the schools on only a part-time basis are part-time workers who are not working to get additional VRS benefits. It's totally up to the school district whether they employ these people or not. Does the IRS consider their time when they're working part-time in a non-benefit position to still be employed?
It is a complicated and somewhat counterintuitive part of the code, but any work with a VRS covered employer is considered, and including work as a contractor for a VRS covered employer, they would consider it continued work, even though they're not receiving benefits for that work. So they couldn't come back part-time and under normal circumstances and continue to receive their benefits.
Thank you.
Are there any other questions? Okay. Is there a motion on the bill that apparently would have potentially serious unintended consequences? It's been moved. Is there a second that the bill be PBI'd?
Second.
It's been moved and seconded the bill be PBI'd. Call the roll, please.
Senator Saslow. Senator Norman. Senator Hanger.
Aye.
Senator Lucas.
Aye.
Senator Newman. Senator Ruff. Senator Vogel. Senator Barker.
Aye.
Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Eben.
Aye.
Senator McClellan. Senator Howe.
Aye.
11 ayes, 4 nays.
11 ayes, 4 nays. The bill is passed by indefinitely.
Thank you for your courtesies, Madam Chairman. I appreciate it.
Thank you, Senator. Let's see. Let's go to Senate Bill 5017, Senator Boysko.
Thank you, Madam Chair. Madam Chair and members of the committee, I present SB 5017.
I'm sorry, I can't hear you.
Okay. Can you hear me now?
Yes.
Okay, great. I have 5017, which is a change in local correctional facility definition. It would allow the Commonwealth to inspect the local corrections facilities being used to detain our immigrants. The bill was amended in the Senate Rehab and Social Services Committee to narrow the scope to public health functions as requested by advocates in the legal community and by Secretary Moran's office. It will allow the State Board of Local and Regional Jails to set minimum sanitation standards and allow for unannounced inspections. It would allow the board to prohibit confinement and require transfer of prisoners in the substandard if they were found as substandard facilities. It would allow the board to review the death of an inmate, to provide circuit courts with the authority to enforce the board's orders. It would allow for access to the interior of the facility by members of local governing bodies, the Department of Corrections staff, and state and local health departments. And as you are probably aware, COVID-19 infections were found at the Farmville facility. 75% or more of the inmates and detainees tested positive at one point. I understand as of today, they have no positive people at this point, but there were very serious problems getting into the facility. Many people, including our federal legislators, Governor Northam, asked the federal government to allow the CDC to step in, and it took a lawsuit to bring in the federal court to get the federal oversight. There is a fiscal impact for this bill. The Office of Secretary of Public Safety believes that a part-time or one full-time investigator may be needed to support the additional workload. Would be an estimated $39,000. The cost of one non-sworn full-time investigator is estimated to be about $64,000. And they also said that there is an estimated $2,500 for travel. The Department of Criminal Justice Services expects that it could absorb any fiscal impact within its existing budget. And I ask that you support the bill and pass it to the Senate floor.
Madam Chair.
Are there questions for Senator
Madam
Boysko?
Chair.
Senator Marsden.
Thank you, Madam Chair. I have visited the, about a year and a half ago, I think it was, or 2 years, I visited the facility in Farmville, reviewed their operating procedures, toured the facility, talked to staff, and found it to be a very, very well-run organization. Our problem here is that, they are a private contractor to ICE. To house immigrants who are undergoing deportation review. While they're there, they go through teleconference reviews and hearings with the federal government to determine their status here in the United States, whether they're to be deported or not, these kinds of things. So it's a federally run facility. I support the concept of this bill in terms of additional oversight and assistance to this organization, but their problem is not how they're operated and what they do with people, but their lack of being able to control who comes into the facility. Under current situations, under the current situation that led to this bill, ICE put people in this facility who were COVID positive. In a somewhat irresponsible fashion. My concern here, and I'll probably abstain on this to get it to the regular calendar, my concern here is that we're going to get into a fight with the federal government that we may not be able to win, and it will involve a lot of additional costs for litigation through the Attorney General's office to fight federal preemption, which is what's going to be argued here. There's good arguments to make that this is constitutional and we have a right to go in, and there's arguments to make on the other side. But I think what I have in talking with some of the representatives of ICA, the facility that runs the Farmville facility, that we could arrange for a letter of understanding, a memo of understanding with the with ICE that would allow for inspection through a member of the Virginia Department of Health and a member of the legislature to go in when there is a problem, to offer assistance and to see if anything is amiss. And this could avoid some difficulty. I don't know what the status of that will ultimately be and what ICE is willing to do, but getting into a tussle with these folks is something we may not be able to prevail in, and this is an alternative solution to the problem. So I just want to keep this in folks' minds. I do think the bill needs to pass today, but I think it needs to be on the regular calendar so that if there's something that an agreement can be made with ICE as to how to handle this, it could avoid some expensive litigation and other state expenses. Thank you, Madam Chair.
Thank you, Senators. Senator Norman.
Thank you, Madam Chairman. I associate myself with most of the remarks that Senator Marston made because I have great respect for his experience and expertise in this area. I am very concerned about the issue of federal preemption, and I have no anticipation that ICE is just going to roll over. I know there's not going to be a resolution on any letter of intent between now and the time we have to deal with this bill. The other underlying thought that I've had, and there are those who may consider this cost de minimis, I think this committee needs to be very parsimonious in the way that we start passing bills in a special session that have reoccurring expenses. We're not talking about one-time expense, we're talking about reoccurring expenses. And there's going to be enough pressure on us to address some large ticket items that may or may not be reoccurring expenses. And while I think that the approach on this by the patron is certainly laudable and altruistic, that it's just not a good policy for us to take at this time.
Madam Chair?
Just an editorial comment. I totally agree. There's a lot of pressure on us, and there's very little money. So thank you for saying that.
Madam Chair?
Yes.
Senator Eben.
Senator
I just
Eben.
wanted to remind the body that the committee, that we passed during the regular session SB 20 that required that the Board of Juvenile Justice promulgate regulations governing housing of youth who are detained in a juvenile correctional facility pursuant to a contract with the federal government. So we have before made policies about what can be done and can't be done when we get into a contract with the federal government or one of our facilities. We just wanted to call that to the committee's attention.
Thank you. Is there anyone else who wants to speak on this bill?
Madam Chairman.
Senator Roth.
Senator Marston, having heard what Senator Eben just said, does that relate to that at all?
Senator Marsden.
As I understand, no. That's a situation where the federal government is contracting with a Virginia government entity for the housing of their folks. This is a privately operated facility contracted for by ICE. I guess local zoning was considered in Prince Edward County or the town of Farmville to allow this facility to operate there. And, there really is no connection between the operation of this facility and Virginia government that I'm aware of. My understanding is, and in reviewing it, their standards of operation will not be exceeded by the ones that Virginia has in place. They're substantially the same. The federal, very often federal standards are more stringent than Virginia. The real issue here is how to deal with this problem and solve it as opposed to getting into an impasse. But no, I don't believe that Senator Evans' thing there is applicable here. Thank you.
Madam Chair.
Thank you.
Anyone
Madam
else?
Chairman, I
Madam
would
Chair.
simply point out that the COVID has gotten into a lot of institutions. Just up the road from Farmville in Buckingham County, there have been several deaths in several of the prisons that are operated by the state and owned by the state. We've had the same problem. So if this is just to solve the COVID issue, this is not the right solution.
Madam Chair. Peterson.
Senator Peterson.
Thank you. I appreciate the bill, and I've listened pretty closely, and I know Senator Morrison has the institutional expertise here. I have two concerns. One is, I don't see how this is legal under the Supremacy Clause. If we have a political subdivision that owns their own facility, their name's on the title, and they contract with the federal government, and the federal government has their own regulations, which would preclude any regulations we would have in regard to their facility, I don't see how we can come in and further regulate it, number one. Number two, and this is more just practical, you know, I've been pretty consistent in this session saying if we're just going to be here and replay every debate we had 6 months ago, we're going to be here a long time. And I feel like this is an idea that's probably better off in January.
Madam Chair.
Senator Boysko.
Thank you. I'd just like to clarify a few things here. One, the bill will bring this facility into the definition of local correctional facility, which means any jail or other place used for detention or incarceration of adult offenders, excluding a lockup, which is owned and maintained or operated by a political subdivision or a combination of political subdivisions for the purpose of sections 51.1-68B, 51.169, 51.169.1, 51.170, 53.127. This term shall also include any facility owned, maintained, or operated by, which is the Farmville facility, any political subdivision or combination of political subdivisions of the Commonwealth that is used for detention or incarceration pursuant to a contract or a third-party contract with the federal government or any agency or contractor thereof. I also would like to provide a little bit of case law that show other examples of state law that regulate detention centers that do not get involved with, the preemptive federal law. California, AB 103, a recent decision from Federal Appeals Court, United States versus California, 921F.3D 865 in the Ninth Circuit in 2019, shows that the GA can promulgate protections to ensure the health and safety of detainees in their Commonwealth. In that case, the federal government challenged AB 103, a 2017 California law requiring the state attorney general to inspect county, local, and private immigration detention facilities in California and to report the conditions of confinement and the standards of care that the detainees received. The law also requires the detention facilities to give the California AG all necessary access to perform these inspections. The Ninth Circuit also found that California's health inspection law was not preempted by federal immigration law because it did not constitute an obstacle to the federal government's enforcement of its immigration laws or detention scheme. The same is true for the Virginia's health inspection law that I'm carrying. Like California, the proposed amendment in the Virginia law does not regulate whether or not or where the immigration detainee may be confined. It does not require the federal detention decisions of removal proceedings conform to state law or mandate that ICE contractors obtain a state license. Even if a state health inspection might be required, some facilities are quasi-federal action to permit inspections and produce data that would not implicate preemption concerns. In the California case, the Trump administration conceded that states possess the general authority to ensure the health and welfare of inmates and detainees in facilities within their borders. As does the Supreme Court has said, the preemption analysis Courts should assume that federal law does not supersede the historic police powers of the states unless that was the clear and manifest purpose of Congress. Citing Arizona versus the United States in 567 U.S. 387, 400 in 2012. The Ninth Circuit found nothing in federal immigration law or in ICE's contracts that showed any interest by Congress to supersede the state's authority to protect detainees in their territory. Thus, the court found state inspections for health of ICE detention facilities were not preempted by federal law. Therefore, a state health inspection of Virginia's ICE detention centers would likely survive a preemption challenge. Michigan also blocks the sale of local jails to ICE because it was determined that ICE was unable to agree to terms that guarantee that this facility would not be used to detain adults who had been separated from their children. And then Illinois passed a law banning private immigration detention centers, HB 2040, and the law says detentions require the exercise of coercive police powers over individuals that should not be delegated to the private sector. Issues of liability, accountability, and cost warrant the prohibition of the ownership, operation, or management of detention facilities by private contractors within the state. That was the Illinois GA, HB 2040. What I believe we're talking about
Senator?
here... Yes, ma'am.
I think we've gotten your point.
Okay, thank you.
Thank you. Is there a motion on the bill? Is there a second to report? Moved and seconded to report. I think clerk will need to call the roll.
Senator Saslow. Senator Norman. Senator Hanger. Senator Lucas.
Aye.
Senator Newman. Senator Ruff. No. Senator Vogel. Senator Barker. Senator Edwards. Aye. Senator Deeds. Senator Locke. Senator Peterson. Abstain. Senator Marsden. Abstain. Senator Eben.
Aye.
Senator McClellan. Senator Howe.
Aye.
Eight ayes, 5 nays, 2 abstentions.
Thank you. Senator Boysko, you have another bill, Senate Bill 5034.
Yes, ma'am, and we just did the easy one, so.
Mr. Chairman, we do not need to hear every case that's been decided in the jurisprudence of America.
Yes, sir. Thank you.
Thank you.
Madam Chair, first I have an amendment in the nature of a substitute, and I move that we pass that or accept that.
The motion is to adopt the substitute. All in favor, say aye. 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 Any opposed? Substitute's adopted.
Thank you. To give you, so this is the earned sentence and release of prisoners bill 5034. It includes Senator Bell's bill, which we just heard, and it also has a component to increase the amount of sentence credits earned by inmates who participate in rehab programs and good behavior.
Madam Chair, sorry.
Senator Norman?
Before
No,
the good senator gets too far, do we have the substitute? This is a mega bill, and it's one that I think we should have. Is this substitute available to us, or can we?
Madam Chair, the substitute's available on LIS under the bill history. You'll see a link for substitutes offered.
Madam Chair, would that work? Thank you, and I apologize to the gentlelady.
Thank you, Madam Chair. The amendment of the nature of the substitute adds an additional list of crimes that exclude inmates from eligibility after consultation with a number of our colleagues who expressed concerns specifically around human trafficking of children and child pornography. It also, and I'm not going to read all of them unless requested. It also includes implementation language to delay the effect to July 2022 in recognition of the budget realities that we're facing due to the pandemic. The added language also sets up a work group to analyze the costs and savings that we can expect from this bill, including the number of inmates who would benefit from the program and which correctional facilities they will be leaving. I will not go into the details of the bill unless you would like me to, for interest of time. It was my hope at the beginning of this process that we would have made this policy available to everyone. However, members of this body have shared their very strong concerns that they wish to make sure that we are narrowing the scope to nonviolent and making sure that any crimes against children are also excluded. And I hope it is the pleasure of the body to pass this on to the floor.
Madam Chair.
Senator Peterson.
First of all, I want to thank the gentlelady for a very important and very comprehensive bill. As I understand it, just reading it, and I wasn't in the rehab committee, subpart A of 53.1-202.3 is effectively the exceptions, because that's where you keep the 85% of time served. Is that correct?
Can you tell me exactly where you are in
If I'm looking at lines 24 down.
of the substitute or?
Yes,
Okay.
the substitute.
Sure. I'm just
No,
trying to pull it up here.
If you go to line 24 of the substitute, it talks about 4.5 sentence credits may be earned for each 30 days, which, using my Fairfax High School math, means effectively a 15%.
Correct.
So
And that's what we have currently. And currently, that's open to any inmate who is eventually going to be released.
So
these are
question,
the
Madam Chair.
exceptions.
So these are the exceptions to?
Correct.
Okay, thank you.
Thank you.
Madam Chair?
Senator Barker.
Yes, I make a motion that we amend the substitute in 53.1-40.01 to be consistent with Senator Bell's bill, which we acted on just a little bit ago, and that's on lines 12 through 23 to deal with the issue of physically disabled.
Okay, all in favor of that, well, I guess those amendments, please say aye. Aye. Any opposed? Okay, those amendments are agreed to. Are there any questions for Senator Boysko?
Madam Chair.
Senator Newman.
Madam Chair, to the patron, I understand that there has been some narrowing amendments, but for those that meet the category in this section, this basically means we will be, as I see it, reinstilling parole and eliminating the common term that we call truth in sentencing. In other words, a jury may give someone 5 years for an action, and in the end, that individual will not serve that amount of time, but instead will follow somewhat in the guidelines that are in this bill. Is that correct?
Madam Chairwoman, I would like to clarify that this is a little bit different than parole. The incarcerated individual would be required to abide by all of the requirements as stated by the DOC. They would have to make sure that there were no infractions to keep the high level of earned sentence credits. They would basically have to have no infractions and would have to really just have the best behavior and go through all of the rehabilitation, the job training, the education programs that were provided. At the end of that time, this would not go through the parole system. So I'd just like to make sure that you understood that. And did you have another? I'm afraid that I missed your second question, Senator.
Madam Chair.
Yeah, Senator Newman.
I think that is a good distinction, that it'll actually be kind of automatic good time, but I guess what goes without saying is that it will kind of move us back away from our truth in sentencing law in general that we've been operating under. So I don't have any further question. I think she has described it correctly. Thank you, Madam Chair.
Madam Chair.
Thank you. Senator Norman.
I apologize through my oversight. I had not picked up on the substitute, and this is a very, very significant deviation from the existing policy, and that doesn't mean that the existing policy is sacrosanct. But as you go through that on the level one, it starts out at a 40% credit. By the time they're in the fourth year, they're getting 25 days of credit for every 30 days. I would respectfully ask that, because you already announced that we've got to have a subsequent meeting, I'd respectfully ask this to go by for the day with the idea that we would take it up as the first bill on the next meeting.
Without objection, we'll pass it by for the day.
Thank you, ma'am.
Thank you.
Next up, let's hear Senator McDougal's bill 5113.
Thank you, Madam Chairman. I do not think that you will find this as earth-shaking change of policy, but Madam Chairman, as many of you know, back in 2009 and 2012, we started putting in place what we called crisis intervention training. It started out rather slowly for law enforcement, but in certain areas of the Commonwealth, like here locally, Metro Richmond, Henrico has a very advanced program. A number of other local departments have taken their crisis intervention training very seriously and have put together some stellar programs. But it is not as pervasive throughout the state as many of us believe it should be. And this bill simply says that in the budget we would have a sum sufficient in order to provide crisis intervention training for new and existing law enforcement officers. And that training would be basic for those who do not have it and more advanced for officers that have already been exposed to that crisis intervention training. So I think that this is a universally accepted thought that this training is very helpful as law enforcement encounters some difficult situations, whether it be mental health, autism, alcohol, substance, whatever that situation might be, where an individual is having challenges in the interaction with the officer. This would help them to de-escalate and address those challenges in a more respectful and safer fashion.
Senator, your bill is similar to Senator Edwards' 5014, and he has asked that we not hear that today so they can get additional information. And I assume that additional information would help your bill as well.
Madam Chairman,
if you don't object.
I do not object. I would just ask the committee, as y'all are reflecting on it, I think as I read Senator Edwards' version, it was for similar training at the academies when an individual is certified. Mm-hmm. What I'm proposing is in the training that an officer does to keep their certification, which is that 40 hours a year, that it be included for all officers, not only when they begin their stint in law enforcement. So as the committee is looking at that, I think it's really important to keep that continued training year after year in place.
Thank you. I couldn't agree with you more, actually. Okay, next up is Senator Hashmi with Senate Bill 5035.
Thank you, Madam Chair and members of the committee. Senate Bill 5035 really emerges in a response to a call to action by many different groups and advocates. This bill is designed to provide transparency and accountability for our public police departments. And this bill is enabling legislation so that our localities, if they so desire, can establish civilian review boards or CRBs. Currently in Virginia, CRBs are limited in power and don't have the kind of regulatory authority that they need in order to serve the cause of the public well. An effective CRB would ensure that police officers act with integrity and they are empowered by self-governance and a culture of respect, and that they work towards establishing social and racial justice. This particular bill gives the localities the opportunity to establish a CRB with subpoena power that can compel the production of documents and witnesses, allowing them to gather, analyze, and review information, produce public reports, and make informed decisions related to policing issues of significant public interest. This bill is, again, it's enabling legislation for those localities that seek to establish CRBs. It does not include the localities with sheriff's offices, and it is also not a mandate across the state. And with that, I would urge that the committee members consider the bill.
Thank you, Senator. I have in my notes that you have a substitute with technical changes. Is that correct?
I believe the substitute was passed in committee in general that previously heard it. That should be available already.
My understanding is that there's another substitute with technical changes from this committee staff.
Yes, Madam Chair, there's an additional substitute that not all of the courts or the judiciary substitute changed reference to an oversight board, and not all of those were caught in the court substitute.
So these are basically technical changes in this substitute?
Madam Chair, we have a committee substitute that makes all the technical changes.
Yeah,
Yes.
That's my question. They are technical substitutes. In our committee's substitute, it is dealing with technical changes, not substitutes.
Yes, ma'am. The other change in the substitute that we were asked to draft clarifies that when the localities pay for legal counsel, instead of saying the locality pays for it, it says they appropriate. It's paid out of funds appropriated for such purpose.
Okay, let's have a motion to adopt the substitute. It's been moved. Is there a second? And seconded that the substitute be adopted. All in favor, please say aye. Aye. Any opposed? Okay, the substitute's now before us.
Madam Chair,
Senator Newman.
I guess to the patron, is this required currently before someone can set up a citizen review committee? In other words, I've been told that there's a version of this in Bedford County. I thought that Charlottesville had moved down this road. Is there a requirement to have enabling legislation to allow what's happening to continue to happen, or is it that by prescribing these things, you are giving these boards prescriptive authority, including the authority to subpoena and otherwise?
Madam Chair and Senator Newman, at present we do have some CRBs established in the state, but these are civilian review boards that really do not have the kind of authority that many of our citizens groups have been asking for. So this enabling legislation allows the localities to establish CRBs that are independent of police departments, that have subpoena power, and that have the opportunity to make binding decisions once they've reached their determination. And so this is enabling legislation that grants greater power to the CRBs, which presently do not have that authority.
Madam Chair.
Senator Saslaw.
The question I have, and granted I'm looking at, I guess, the original version or one of them, do they have the right to require the local people to fire an employee? Because it says here, unless you've changed it, it says they can make binding disciplinary determinations in cases that involve serious breaches of departmental professional may include letter of reprimand, suspension without pay, suspension with pay, demotion within the department, reassignment within the department, termination, and voluntary restitution. Is this something that then the local government has to comply with?
For those localities, sorry, Madam Chair and Senator Saslaw, for those localities that establish a CRB in this order, they would have that power to make binding decisions.
Madam Chair.
Senator, if I could then say, but they're not required to. Or are they?
I'm sorry, Senator Howell, were you? I didn't hear your question.
Oh, I'm sorry. Well, it's the way I'm reading this is the localities could implement those criteria, but they're not required to.
Madam Chair.
Senator Peterson.
It's in Part B, it says a locality may establish a law enforcement civilian review board. Such a board may have the following duties. So the locality itself would have to enact that charter.
Thank you. Is there anyone else to speak on this?
Madam Chair.
Yes, Senator Newman.
Before I came here, I met with all the prosecutors, the law enforcement for my entire area, and this was one of their greatest concerns, is not setting up the boards or the pathway to the boards. It's exactly what Senator Saslaw said, and that is that these individuals that have no knowledge, as a matter of fact, the current law enforcement person is forbidden from being on this board if you follow this section, that they are going to be given the right to fire, hire, demote individuals based on items that are kind of outside the purview of what a normal HR would do. I think that section of this bill is extraordinarily problematic. So I would hope that if that stays in and it's in the substitute, that we would not pass this.
Any further discussion?
Madam Chair.
Senator Peterson.
I want to speak in favor of the bill, and I'm not one who's going to vote for every single measure that comes down the pike this session. There's some I've already voted against, and there's going to be others, especially when bills come over from the House. But I think this one makes sense, and here's why. We have localities with populations that feel like, for whatever the reasons, they're underrepresented and underserved in law enforcement, and this gives them a mechanism to deal with that. And again, it's up to the locality to implement that and to put parameters around that. And if that locality enacts that policy and it has a negative effect on their police force and on their morale, that's something they're going to have to balance. We can't micromanage that here from the state Senate. So I think this is a good idea. I think it's a really good idea. Again, this is no disrespect to law enforcement officers whatsoever. It's just we're giving the locality the ability to control their own police force, which is basically how they face the public, and giving them a method to inspire confidence. And again, if they don't choose to utilize it, or if they choose to utilize it in a more moderate fashion, that's going to be up to them. But again, we're not here to micromanage that.
Madam Chair.
Senator Deeds.
Building on what Senator Peterson said, localities already have the ability to control their police force. What we are empowering right now is the inclusion of citizens and helping make those decisions. And we are just simply including a list of powers that the localities may give those citizen review boards. This is a good idea. It's about democratizing the process of local government, and I think it's, at least the people I represent are calling for something like this.
Thank you. Anyone else? Is there a motion on the bill? It's been moved and seconded that Senate Bill 5035 be reported. Call the roll, please.
Senator Saslaw. Senator Norman. Senator Hanger. Senator Lucas.
Aye.
Senator Newman. Senator Ruff. No. Senator Vogel. No. Senator Barker. Aye. Senator Edwards. Aye. Senator Deeds. Aye. Senator Locke. Aye. Senator Peterson. Aye. Senator Marsden. Aye. Senator Eben.
Aye.
Senator McClellan. Aye. Senator Howe.
Aye.
Ayes 11, noes 5.
It's reported by 11 to 5. The next bill up is Senator Reeves' Bill 5053.
Thank you, Madam Chair. This bill came out of committee as well, unopposed, and I think this bill does two main things, but I'd like to share a little background with the genesis of this bill. This summer, when some of these things were happening, I, like a couple other members here, convened a working group of about 40 to 50 people that are involved in law enforcement day in and day out. And one of the things that was concerning was the rise in hate crimes. Little statistics for you. According to the VSP, crime statistics for 2019, race intimidation crimes were the leading arrest category for hate crimes in Virginia. According to the most recent FBI statistics, personal attacks motivated by bias or prejudice reached a 16-year high in 2018. The truth is those numbers are more likely severe than the FBI indicates. According to the Bureau of Statistics report on hate crimes in America, 54% of people who are victimized chose not to file a complaint that were victimized as of a hate crime. I think today this committee has the opportunity, and we as a chamber, to send a clear message to both those folks who perpetrate these things, these crimes, that race intimidation crimes are not to be tolerated in the Commonwealth, and that offenders are going to face some severe punishment. So the bill is very simply, if you look at it, it addresses 3 code sections. It's taking a Class 6 felony and making it a Class 4. And in one code section, 18.2.423.1, it goes a little bit farther with regard to placing a swastika. It takes out school, educational facility, community center owned or operated by a church or religious body, and basically expands that to the property of another, a highway or other public place. And Madam Chairman, that's what the bill does. I understand we are in a budget crunch. I'm not sure that the fiscal impact of this is all that great, but it certainly is a great impact that we can make a statement to all Virginians that we're just not going to tolerate hate crimes. That's the bill, Madam Chair.
Madam Chair? For Senator Reeves, can you remind me the difference between a Class 6 and a Class 4 penalty, what we're increasing the penalty from to what it would be after your bill passes, presumably?
I am a little rusty, Madam Chair, on time and fine. If you can give me a second, or maybe counsel can tell me the difference, or one of you defense attorneys.
Madam Chair, Charles Quagliato from Legislative Services is on the phone if you'd like him to respond to that.
Madam Chair, I think Senator Deeds could probably turn and answer his seatmate's question for him.
Let's have Charles
I'm happy to help.
Charles,
Chair,
are you there?
Charles Quagliato here from Legislative Services. A Class 6 felony is 1 to 5 years, and a Class 4 is not less than 2, no more than 10. 4 to 5, going up to 2 to 10.
Is there any further question for staff?
I have a question, Madam Chair,
Senator Peterson.
and this is a question for staff, and I don't spend as much time in Section 18.2 as some folks here, but we're making a Class 4 felony for swastika.
I did it electronically.
Burning a cross, obviously, that's a Class 4 felony.
Thank you.
I guess, do we have any other, if you write something threatening to a group of people where we say that's a felony, a Class 6, a Class 5? I just mention this because, a Class 4 felony is you're talking about the same penalty somebody gets for manslaughter. That's pretty stiff penalty. Could be somebody, obviously, somebody doing a bad thing who's, but again, we're changing this to be basically the equivalent of killing somebody. Do we have any other type of similar property crime that we treat this way?
Madam Chair, these bills are all grouped in the article titled Activities Tending to Cause Violence, and they include the mask wearing section, the prohibition of wearing masks, the cross burning, the displaying of noose and swastika. So these crimes are all about intimidating groups of people. But to answer Senator Peterson's question, there are no other, I'd say, felonies outside of these activities that exist.
I'd just like to note that this bill came out of judiciary unanimously, and our job is to decide if we can afford the $50,000 to implement it. It's been moved and seconded the bill be reported. Call the roll.
Senator Saslow. Senator Norment. Senator Hanger. Senator Lucas. Senator Newman. Senator Ruff. Senator Vogel. Senator Barker. Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Eben.
Abstain.
Senator McClellan. Senator Howe.
Aye.
That's 15, no, 0, 1 abstention.
Thank you, Madam Chair.
The bill is reported. The next bill is Senator Morrissey's bill 5007.
Thank you, Madam Chair. Madam Chair, this bill is not new to this body. It passed, almost an identical bill passed the State Senate last year with bipartisan support after somewhat robust debate. Here's the essence of the bill. The bill will allow a defendant in a criminal trial to opt as his right to a jury trial, but then a judge sentencing. As most everyone in this room knows, right now, the law is that if you opt for a jury trial, you get jury sentencing. 44 of the states and the federal system opt for what this bill does, jury trial, judge sentencing. And as Veka said, nobody is better equipped with including sentencing guidelines, nuances, et cetera, to decide the fate of a defendant who has been convicted by the jury than a judge. As I indicated, 88% of the states have jury trial, judge sentencing. Virginia is an outlier. And I will, in the brief time that I have, I will address what is probably the white elephant in the room, and that's the suggestion that this is going to cost the Commonwealth money. It is abundantly clear to anybody that analyzes it that there's going to be a net savings to the Commonwealth by virtue of the fact that defendants will be sentenced by a judge almost always within the sentencing guidelines, and the terms will be far less than a runaway jury. Let me give you a couple, and by the way, this bill did not even come up before Senate Finance last year, and despite some suggestions by others that it's going to cost the Commonwealth money, it won't. Let me give you a statistic that I think cuts right to the chase. There was a matrix done showing all of those states that had jury trial and judge sentencing, and Connecticut and Nebraska were two of those states. They also had the lowest percentage of requested jury trials in the country. And that's the biggest opponent to this bill is VECA, which suggests that there's going to be an explosion in jury trial requests. There will not be. What there will be plea offers offered by the Commonwealth that are commensurate with the crime that was committed. As I said, two of the states that have jury trial, judge sentencing have the lowest requests for jury trials in the country. Conversely, Arkansas, which has jury trial and jury sentencing, has one of the highest requests for jury trials. So we are not going to have an explosion. A couple of vignettes, and then I'll answer any questions, Madam Chair. When I was Commonwealth's attorney in Richmond in the late 80s, early 90s, before we had bifurcated juries, we did more jury trials than not only any jurisdiction in the state, but almost 20 or 30 of them combined. Judges regularly handled 60 jury trials a year. We had 140 murders a year, now we have 30 in Richmond, and we did a lot of jury trials. We had 16 prosecutors, and that was the biggest and largest Commonwealth Attorney's Office in the state. Now they have 30 murders a year, not 150, and they have 36 prosecutors in that same office. And one final vignette, I'm reviewing a transcript from Now in Hopewell that I think clarifies this and puts this in proper perspective. A defendant had an incident with a police officer, got into a fight with a police officer, and was charged with malicious wounding of a police officer. The offer to the defendant was within the sentencing guidelines of 2 years, 3 months, and a midpoint of 4 years, 6 months. The defendant rejected it, said, I didn't know he was a police officer. Yeah, I got in a fight with him. Went to trial. Rejected a reasonable plea agreement, and the jury came back with 26 years. And the judge did not change that. He said, you picked a jury, you're stuck with it. This case would have gone to a judge, he would have had the sentencing guidelines, and he would have been sentenced within those guidelines. The cost of incarcerating an individual in a year is $24,000 a year, and if you add capital costs to it, it's $44,000 a year. The Commonwealth is going to incarcerate that person for 26 years at $44,000 a year for a crime that warranted about 2 years maximum. I'm not going to go too much more into the weeds regarding the cost of this, but it is clear to my 8-year-old, no, she's going to be 8 in September, that this is going to be a net reduction in cost to the Commonwealth. And to those prosecutors out there that say there's going to be an uptick in juries, there will initially, until plea offers are more commensurate with the crime. So maybe those prosecutors will have to do a little bit more work initially. With that, Madam Chair, I'd ask, I'll answer any questions that the committee may have.
Are there questions for the patron?
Madam Chair.
Senator Deeds.
As I've said before to many people, this is the most important criminal justice bill, in my view, that we have to deal with this session. But I had a couple of amendments, and I think Charles is on the line and can report them.
Charles?
Madam Chair, there is a substitute that should be published very shortly. But basically, the substitute makes 2 changes to the substitute that came from the judiciary. The first change deals with when the request to have the defendant make a request to have the jury sentence. In the substitute that came out of judiciary, the defendant could have elected to have the jury sentence basically at any time until the jury was dismissed. Now it has to be done 30 days before trial and by a written motion making such request. The other change dealt with the sentencing hearing provisions. In the substitute that came out of judiciary, the defendant's criminal history was rather limited to adult felony convictions, and the defendant could introduce any evidence related to sentencing. The substitute that's before you, the proposed substitute, basically restores the language to existing law so that juvenile convictions can come in, out-of-state felony convictions can come in, and the defendant's sentencing evidence is limited to relevant evidence. And those are the changes in the substitute.
Madam Chair.
Senator Deeds.
If I can, well, I think this is incredibly important. This is a big change, and my amendments, which are incorporated in the substitute that I'd move, is that, number one, we would give the prosecutor 30 days written notice that we're going to have jury sentencing. And number two, that we would continue, the prosecutor would continue to allow him to introduce during the case or during the sentencing, when you have jury sentencing, the same sort of criminal history that he would introduce before.
You have moved the substitute.
I've moved the substitute,
Is
yes.
there a second? Second. It's been moved and seconded the substitute be adopted. All in favor say aye.
Aye.
Aye. Any opposed?
And now, Madam Chair, I'd move we report the substitute.
It's been moved that the substitute be reported. Is there a second? Is there any further discussion? Okay. I guess call the roll, clerk.
Senator Saslaw, Senator Norman, Senator Hanger, Senator Lucas, Senator Newman, Senator Ruff, Senator Vogel, Senator Barker, Senator Edwards, Senator Deeds,
Aye.
Senator Locke, Senator Peterson, Senator Marsden, Senator Eben, Senator McClellan, Senator Howe.
Aye.
10 ayes, 4 nays.
10 ayes, 4 nays. The bill's reported.
Madam Chair, thank you very much. Could I broach one other subject before I depart?
I guess.
Thank you. Madam Chair, I have a Senate Bill 5049 that's on your docket, and I would respectfully request that that be incorporated into Senator Locke's SB 5030.
Okay, yes, that's fine. I was just going to say that Senator Locke's 5030 will be the prime bill, and that my understanding is that the patrons of Senate Bill 5049, that's you, Senator Morsi, Senate Bill 5037, Senate Bill 5002, and Senate Bill 5005 are all in agreement with having their bills rolled into the main bill and their names added as co-chief patrons.
I will move we incorporate all those bills and Senator Locke's 5030, and we list those people as chief patrons.
Second. It's been moved and seconded. All in favor, please say aye.
Aye.
Aye. Any opposed? It's unanimous.
Madam Chair?
Okay, now Senator Locke's Bill 5030.
Thank you, Madam Chair. Senate Bill 5030 was addressed quite thoroughly in the Judiciary Committee, so I will try to be brief in addressing what this bill, which is fairly comprehensive, does with the incorporation of the bills so named. The intent of Senate Bill 5030 is to bring equity to Virginia policing, and it is a transparent piece of legislation. We attempted at all times to be transparent in this proposal. We engaged multiple stakeholders in the process. Not everyone is happy, so that usually means we've reached a compromise because we're somewhere in the middle with everything that we have ended up with here. The bill prohibits no-knock warrants. It bans sex with individuals arrested by law enforcement. It prohibits hiring of officers fired or resigned during the use of force investigations. It creates a decertification procedure for law enforcement officers. It bans chokeholds and strangleholds. It requires attempts at de-escalation prior to the use of force. It requires warning shots before shots are fired. It requires law enforcement to exhaust all other means prior to shooting. It creates a duty to intervene by fellow law enforcement officers. It prohibits shootings at moving motor vehicles. It requires departments to create a use of force continuum. It requires comprehensive reporting by all law enforcement agencies, including use of force. So, as indicated, Madam Chair, Senate Bill 5030 is quite comprehensive, but addresses many aspects of policing reform that citizens and advocates in the community have communicated to us that are important to put Virginia on the path to a fair and equitable system. And with that, Madam Chair, I will take any questions that anyone may have.
Are there questions for Senator Locke? Is there a motion on the bill?
I move to report.
Second?
It's been moved. Did I miss somebody? Okay. Lisa.
To be a substitute for this bill, Senator Locke?
We've already voted to roll them all those bills together and have co-chief patrons. Was there something beyond that you were?
I believe Connor or Charles had prepared an additional substitute. Maybe they can speak to that.
Madam Chair, I made motions and my mic's not really working. But Senator Favola just indicated to me there was some language that she worked on with Senator Locke that was. I've got it now.
Connor, can you speak to the substitute, or Charles?
Madam Chair, Charles here. The substitute primarily makes technical changes. There are two different changes, two substantive changes, I would say. The first substantive change deals with 599 funding. In the substitute that reported out of judiciary, there was a provision dealing with the community policing reporting database, that if a locality didn't report information that they would be subject to the loss of 599 funds. That provision has been stricken from the bill. And the other change, and this is a very minor change, dealt with, again, 599 funds, dealing with a locality having to be accredited. In the substitute out of judiciary, the accreditation status had to be determined by DCJS. The proposed substitute also allows accreditation to be done by CALEA, which is the national agency that recognizes law enforcement accreditation for agencies. So those are the only two, I'll say, substantive changes. Everything else is primarily technical changes.
Thank you. Are there further questions?
I'll say, Madam Chair, I believe Senator Favola's language, this is April, Senator Favola's language difference was not part of those changes. She would need to speak if she wanted that difference to that.
Okay, Senator Favola.
Thank you, Madam Chair. Thank you, Senator Deeds, also for the clarification. My bill was heard at the same time Senator Locke's bill was heard in the Judiciary Committee. And as I recall, the motion was to incorporate both her language and my language, as opposed to just slapping one on top of the other. So let me just tell you the three differences that I could move as an amendment if you wish.
Okay.
Okay, so this would be a change to section 9.1-112. So we're dealing with the committee on training, the advisory committee on training, and the membership. My addition, which I believe Senator Locke had agreed to, was to add an attorney representing the Indigent Defense Commission. My second change, if I could make these amendments in a block, I'd like to give you my second change. Okay. I had one mental health provider. It was supposed to be one behavioral health provider. That is that change. And lastly, under the two citizen representatives, I indicated one must come from a minority group, and that was the only other change I had made.
Madam Chair.
Otherwise, my
Peterson.
bill reads like hers in that section.
All right, before we take up these amendments, are we working off of the substitute that's 8:40 a.m. today? Is that the one we're working off of?
Yes, sir.
Yes.
And that has the changes that Charles described about not forfeiting the 599 money, and I think there was one other change.
Sure.
Have we adopted that substitute?
No, sir.
No, it's being amended.
Okay, so the substitute is being, I guess what I'm asking, Madam Chair, is it possible for us to adopt the substitute before we amend it further, or just so we know where we are?
Our recommendation would be to go ahead and adopt the substitute before you amend it.
Before, okay.
All right, second.
It's been moved. Is there a second to adopt the substitute? And seconded. All in favor say aye. Aye. Any opposed? Okay, now are there amendments to the substitute?
So I would move the amendments that I just read, Madam Chair.
Okay. Is there a second to those amendments? It's been moved and seconded. Those amendments be added to the substitute. All in favor, say aye. Aye. Any opposed? Okay. Is the bill in good form now?
Madam Chair,
Okay.
this is Charles again.
Charles.
Since you adopted Senator Favola's amendments, I would also suggest that section 9.1108 in the bill be also amended to reflect those changes, because in Senator Locke's bill, 9.1108 matched up with the Committee on Training. So since we're changing the Committee on Training section, it would likewise be to amend that 9.1108 section, which is the composition of the board.
Would someone like to move those amendments? Okay, they've been moved and seconded. Discussion. All in favor say aye. Aye. Opposed? Okay, those amendments are adopted. Now, okay, it's been moved and seconded that the bill be reported as amended. All in favor? Well, read the roll.
Senator Zaslow. Senator Norman. Senator Hanger. Senator Lucas. Senator Newman. Senator Ruff. Senator Vogel. Senator Barker. Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Evan. Senator McClellan. Senator Howe.
Aye.
Ayes 11, noes 5.
Okay, we can take a big breath. We now have left our committee member bills. I believe there are 4 of them. And the first is Senator Deeds' Bill 5043.
I think there's a substitute that Senator Surville has that incorporates some changes that came from the Supreme Court. Senator Surville's. Okay.
Would you like to move the substitute?
I'll move the substitute.
Second.
It's moved and seconded. The substitute be adopted. All in favor say aye. Aye. Any opposed?
Madam Chair, if Senator Surville wants to talk about those changes, then I'll have a couple other amendments I want to discuss.
Okay, Senator Surville.
Thank you, Madam Chairman. I wasn't aware I was going to explain this, so I'll try and wing it off the top of my head. But there's been some, I guess, dialogue or conversation as these expungement discussions have gone on, specifically, I guess, on the Crime Commission the other day, of which myself, Senator Edwards, and Lucas are a member, where there's a concern about a lack of access to the expungement process. And so what this additional language does is it basically takes all the filing fees that are filed for expungement petitions, and it puts them in a special fund. The filing fee is $90, and there's about 6,000 petitions a year, so this would generate about $540,000. Currently, the fee is refundable. This would take away that refundability, put it in this fund, and then this money could then be used to pay for court-appointed counsel for expungement petitions at $300 per petition, which would fund about 1,500 expungement petitions done for indigent attorneys. I'm sorry, indigent individuals. So that's basically what it does. The Supreme Court looked at the language and came up with some tweaks to make sure it was workable, but that's basically what the substitute language does.
Questions or comments?
I was talking about the changes from yesterday.
Okay, I've lost track. Do we have a motion?
We've already adopted that.
We've adopted the substitute.
Okay, we adopt the substitute. This bill is, other than that and a couple of other amendments that I want to bring up in just a second, is the same bill we saw this past session to allow expungement of certain offenses. There are two other sets of amendments that I'd like to consider. One is from the Legal Aid Justice Center, basically to further reduce the cost of the expungement process and to maybe expand it a little bit. Charles can report those amendments. And there's another amendment from the Supreme Court that takes a look at the cost of this, which is now, I think, $1.2 million, and wants to delay the effective date of this bill by a year. And Charles has that as well.
Okay. Charles.
Hi, Madam Chair. This is Connor Garnska from DLS. So
I'm afraid we can't hear you. Is there some way to raise that?
Can't hear me. Can you hear me now? Hello?
We can barely hear you.
Okay, I'm going to email these to someone else so that they can be explained that way. Apologize for that.
Madam Chair, Charles here. Can you hear me?
Yes.
I believe the amendments, and these are, I believe, are drawn to the substitute that were just adopted. Basically, on line 40, you are, after the Romanet C, you're striking court costs and on line 41, after date of, we are striking the remainder of line 41 through probation on line 42 and inserting conviction. It looks like there's a technical change on line 43 after 18.2-251, striking the semicolon and inserting an and then on line 44, after satisfied, striking the remainder of line 44 through probation on line 45, and then the last amendment is inserting the delayed enactment, which would make the bill effective January 1, 2022. Those are the amendments.
Are there questions about the amendments?
The first amendments the first set of amendments that he spoke of came from the Legal Aid Justice Center, and they work to reduce the cost of the expungement process for the people that are going through it. And then the last amendment is from the Supreme Court that delays the effective date. Simple as that.
Just by explanation of delaying the enactment date, they are in the process at the Supreme Court of updating their technology, and it would be much more efficient to include this rather than do it before the rest of the process, which is the explanation I was told for that. Do we need to vote on the amendments?
Well,
okay, can you move your amendments?
I will move the amendments.
Okay, is there a second? Thank you. All in favor of the amendments, please say aye.
Aye.
Any opposed? The amendments are agreed to.
I will move we report as amended.
It's been moved and seconded that the bill 5043 be reported. Please record the votes.
Senator Saslow.
Dick, aye.
Senator Norman. Senator Hanger. Senator Lucas. Senator Newman. Senator Ruff. Senator Vogel. Senator Barker. Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Eben. Senator McClellan. Senator Howe.
Aye.
Aye 16, no 0.
It's reported 16-0. Next up is Senator Lucas's bill, Senate Bill 5024.
Thank you, Madam Chair. According to a 2018 report issued by the U.S. Commission on Civil Rights, people of color comprise less than 38% of the nation's population. Yet they make up almost 63% of unarmed people killed by police. Additionally, unlawful use of force by police officers rarely lead to discipline, termination, or criminal punishment. The advocacy group Mapping Police Violence found that 99% of police killings from 2014 to 2019 did not result in officers being charged with a conviction or a crime. This bill, Senate Bill 5024, will enable the Attorney General of Virginia to conduct pattern and practice investigations of law enforcement agencies to identify and put a stop to unconstitutional practices such as patterns of excessive force, illegal searches, biased policing, or other unconstitutional practices. For decades, the U.S. Department of Justice was a reliable partner in identifying and ending unconstitutional policing practices. Often, they negotiated agreements for reform called consent decrees in multiple cities. But under the Trump administration, the Department of Justice has explicitly walked away from this responsibility, making it more important for state attorney generals to have this important tool. The bill authorizes the Attorney General to inquire into or seek to conciliate through a lawsuit whenever the Attorney General reasonably believes that the law enforcement officers' agencies are engaging in a pattern or practice that deprives persons of rights, privileges, or immunities. The bill also empowers the Attorney General to issue a civil investigative demand if the Attorney General has reasonable cause to believe an unlawful practice or violation has occurred.
Are there any questions or comments to the patron?
Madam Chair, this is April. April,
Looking
sorry.
the wrong way. Okay, April.
We had notes that we thought there might be a patron amendment related to the conciliation agreement. Is that correct, Senator Lucas?
Not to my knowledge.
All right, then never mind.
We're good.
We're good then.
Okay, is there a motion on the bill?
Move the bill be reported, Madam Chair.
It's been moved and seconded that 5024 be reported. Please call the roll.
Senator Sadlaw. Senator Norman. Senator Hanger. Senator Lucas.
Aye.
Senator Newman. Senator Ruff. Senator Vogel. Senator Barker. Senator Edwards. Senator Deeds. Senator Locke. Senator Peterson. Senator Marsden. Senator Eben. Senator McClellan. Senator Howe.
Aye.
Ayes 11, noes 5.
The bill is reported 11-5. The next two bills on the docket, the patrons have asked that they be passed by for the day, so we'll pass by 5118 and 566. I'll inquire of the clerk. Does that complete our docket?
Except Senator Ruff's bill, you have to vote on that motion if you want it stricken.
I'm sorry. Oh, he's moving to strike. All in favor of striking 5119, please say aye.
Aye.
Any objections? The bill is stricken. Thank you. Thank you, Hobie. Okay. We're done for today. We'll be back.